Awesome. Welcome, everyone. How's everybody doing? So hopefully you're here for Legacy Planning 101, sponsored by Voice and wonderful people helping out with formerly long-term care ombudsman. And just as an introduction, I'm Paul Gantner. So I work with the law firm Gantner and Capriano in Sunset Hills. If you've not heard of us, if you listen to KMOX, you might hear it now. But Margaret has been doing ads for us and doing our kind of commercials on there for probably 15 years or so. Been on there for about 2025, but she used to work with us and then moved out to Kansas City to be a grandma. But estate planning and elder law is what we do. So, this is kind of educational, just the goal is to kind of have you do a little inventory and audit on yourself or your loved one, kind of make sure you've done everything that you can. We're not going to get too much into like the money aspects of estate planning. We can do that kind of in a different forum. It's more about the basic foundation that everyone should have, regardless of how much and how little you have in place to help make sure that you and your family are taken care of. So I grew up here in St. Louis, went to St. Louis U for undergrad, Mizzou for law and MBA. Since we're in St. Louis, I went to DeSmet for high school. Again, very involved in these two areas of law. Missouri has a group of attorneys that focuses on issues of seniors, kind of from retirement through until the time you pass away. And that's this area of law called elder law. And a lot of states have it, but here in Missouri, we have about 145 attorneys that belong to this group called the National Academy of Elder Law Attorneys. And I'm currently the past president on the board of that. So whenever you're looking into issues, I think the last session was about paying for long-term care, and that is a big area of law that we deal with as well. And then of course, not everybody that does estate planning does elder law, but a lot of the people that do elder law also do estate planning. So the American Academy of Estate Planning Attorneys is another place to look. One of the coolest kind of recognitions that I got last year, if you ever read the St. Louis Business Journal, I got named to 40 under 40 last year on that. So that was pretty cool. And you're probably thinking, guy's under 40, but I got there in my last eligible year, so I'm not able to do it anymore. So so by 2060, nearly 1 in 4 Americans are going to be 65 or older. We all kind of heard of this, right? The boomers kind of getting older, so these issues are coming up more and more, and those 85 and older will actually triple. And they talk about a lot of people's retirement plans and planning, as they reach that retirement age, is to get them through like 85 or 90. They're really saying now you should plan to get into potentially the hundreds, because that number is going to grow as well. It'll add more than 500,000 centenarians during that time period. Now, only 20% of Americans currently have any form of advance directive. Now, I'm going to talk a little bit more about what that is, but advance directives, if you aren't familiar, is kind of that, if you're in a bad position and you're not going to get better, what do you want to have happen? And you can get very detailed on that, or you can have general statements, but that's a really small number because the default rule is keep you alive forever. And that's not most people's goal or wishes, because most people don't want these things to happen if they're not going to have high quality of life. As of December of 2022, 46 states have what we call default healthcare surrogate statute. That means if you don't have a plan, they've made a plan for who can make medical decisions for you. Everybody know how many states there are in the United States? So that means there's 4 that don't. Anybody recognize any of those state symbols up there? So Missouri is one of 4 states in the United States that there is no default healthcare surrogate law. Now that's a lawyery way to say, I know most people think if I get sick or I'm in the hospital or I'm put on a ventilator with COVID or whatever, My spouse can make my medical decisions for me. No, they cannot. Your spouse has no rights to make medical decisions for you if you can't make them yourself. Some people think, well, my adult children, they must be able to make medical decisions for me. No, they cannot. There's no default healthcare surrogate, which means no one on earth has that authority. You have the right to make your own healthcare decisions, but a lot of the stuff we're going to talk about means by default, you have no ability to make those decisions. So if we wait until we need it, what's the problem? It's too late. We can't have you tell us who should be making those decisions at that time. So we got to go through a really difficult process. Now we might be saying, well, I don't know, when my parents, they were sick and I was in the hospital room and some doctor walked in and just goes, are you family? And then you say, yep. And they go, so here's what's going on. They're breaking the law. And that happens less and less now because people get sued for that. That is a violation of HIPAA right away to talk about anyone's healthcare decisions about anything. And as I said, there is no one that has the authority to make any decisions about take that pill or take this pill or have this surgery. So other states may have a default healthcare surrogate, but what's the problem there? Maybe it's the wrong one, right? Maybe you don't want that person in charge. So I really encourage everyone, what could be a more important thing than if you get bopped on the head, who will be making decisions for you? And some people have a perfect answer for that. They say, well, obviously my spouse, and then my only child, and then my oldest grandchild, or whatever your order is. Other people don't have a perfect person. They're like, well, I'm not married, I don't have any kids, and I have some friends, but that might be asking a lot. Just imagine you're in that scenario and it's too late for you to do it. Who would you have chosen at that point? Because sometimes you got to play defense against the worst case scenario. Now, while 92% of Americans say it's important to discuss wishes for end of life care, only 32% have had any such discussion. A lot of the legal forms that we're going to talk about kind of lay out general rules. But what do you think the problem with saying, I want to be kept on a machine for 2 weeks, and then if I'm not getting better, pull the plug?
Who determines when you get better?
Right. Well, who determines that? Who determines if 2 weeks is not enough because it'll take you 4 weeks to recover fully in your lungs, or 2 weeks is the most miserable 2 weeks of your life, and you're never going to come out of it. And they just have machines keeping you alive. So you can't get super specific, but what you can do is arm whoever will be making your voice with kind of like anecdotal evidence. Oh, remember Uncle so-and-so? I would have pulled it 2 days before that because of this, this, and that. Or maybe there's just general guidelines that you can put in your documents. But the important thing is to have those conversations. And it's not fun to necessarily have, their kids or whatever will say, oh, I don't want to talk about that. It's Thanksgiving or whatever. But find an appropriate time, maybe bring them into your attorney's office when you update the things and just kind of have general conversations about it, because it's such a moving part. Their job is not to do what they would do if they were in that situation. Their job is not to do what the doctor would do if it were their spouse. What's their job? Do what you would want them to do if you were sitting there right next to them. So this is the best way to do that. So again, most people say they would be willing to talk about it. And most actually say they'd be relieved to. So I'm going to talk about two different families and kind of these essential documents and how it works if they have a good setup and how it works if they don't have anything set up. And we'll see what one we think is a little bit better. And then we'll have plenty of time to answer questions and things too. So what are your options? No planning at all, right? It's 100% easier to do nothing than to do something, right? So a lot of people are stuck in this, I'll get to it. And this means we've got the default rules, which at best means the state of Missouri has decided what's going to happen to you. And as I've already discussed, in many cases, there's no rules about what you can do or not do. So I don't recommend that. The next option is kind of this traditional planning. Most of us think about all this stuff in the estate planning arena as some document you got to sign before you die, right? And maybe many of you did this like 10, 15, 20 years ago. You got all these documents, you signed them, you threw them up on a shelf and you said to your kids or whoever, if anything ever happens to me, I did this planning. And in the meantime, they're just gathering dust. You don't really remember what they say or even who's in charge, but you got those documents. What I would encourage you to do is kind of look at it and think of it as more of a legacy wealth plan. Now, those kind of seem like flowery terms, but legacy to me means how do you want to be remembered? Because a lot of families, and maybe a lot of people in this room know somebody who doesn't even talk to half their family anymore because of what happened when things went south. Either somebody passed away or got really sick and all there is family fighting and no more family parties and all that stuff. Or you can have planning that works and you can be remembered as somebody who is a good steward. And wealth. A lot of us think that term wealth means millions and millions of dollars or it's not worth doing. No, whatever stuff you have, you should have a plan for. And so, like many things in life, timing is everything. I kind of already alluded to this, but all of these things we're talking about have to be done before you need it. Because if we're talking about when you need it, it's too late. And I can tell you, I get calls at my office sometimes with, hey, my dad's at the hospital. We don't have any documents. We can't get any information. Can you run up here and have him sign some powers of attorney and things? You know, he's on a ventilator and can't speak, but what do you think the problem with that is? Can I just grab his hand and Ouija board him on there? We have no idea that he has to understand what he's signing or he can't sign. So you got to do it beforehand. So Bill and Mary is kind of a typical firm client that would come in, talk about what they're trying to achieve, what their concerns are. You know, if you know, it happens, but it's kind of rare to go healthy, dead. Right? Car accidents and things like that do happen, but a lot of times it goes healthy. Oh, something happened, but we're still alive. We've got a lot of things going on. We're in the hospital for a few weeks. Maybe we went to rehab or we, have to spend some time in long-term care. One other statistic I didn't put up there is if you're 65, you have a 70% chance of needing long-term care at some point before you die. 40% that you'll spend time in skilled nursing. And 20% that you'll be there for longer than 5 years. Now, I want to grow up and go to a nursing home, said no one, right? You know that? I know, I can't tell you how many people said, well, don't worry, I have a plan. My spouse is going to smother me with a pillow if anything ever happens. But the reality is within 25 miles of where we are right now, there are over 100 skilled nursing facilities, most of which are near capacity or even at capacity. So people are spending some time in that scenario. And maybe it's even a temporary thing. But if it's a temporary thing, we still need to know who's going to manage your finances while that's going on. Who's going to make your medical decisions? And again, beyond the scope of today, I'll talk kind of high level about differences between a will or a trust, but like I said, I'm not going to get too into the weeds about that stuff, but who do you want to get stuff? And how should they get it? So one of the things that I started doing like 15 years ago was this essential planning documents, 5 documents everyone should have. And so we're going to talk about those because one of the things that I'm going to tell you is not all of these documents are created equally. Just like everything, there's good ways and bad ways to do everything. And if all wills were the same and all trusts were the same and even all powers of attorney were the same, what would you do in 2023 to get the best price on any commodity? Shop around, and you know how easy it is to shop around in 2023? Go to Google and say cheapest will in St. Louis, enter. And most people say, well, no, Paul, I know that not all of them are the same, but then people will call the office and say, how much is it for a will? How much is it for? That question doesn't make any sense unless they were all the same and you could compare apples to apples, right? But I can tell you there are places out there, if you Google cheapest will package in St. Louis, there's Groupons available for $29.99 and take your shot with that. But those are often poorly drafted, a lot of times drafted even for nationwide. Like if you read the fine print, they're like, these were drafted in Nevada, but and not not done by attorneys or blah, blah, blah. So it causes a lot of lawsuits and a lot more, pain on the back end. So what should we have in place? First thing is a property power of attorney. Now, this is probably the hardest one to find any useful free version of. And why do you think that is? Does anybody know what a property power of attorney does? Never heard of it? So like a financial legal agent that can work on your behalf. So it's when you sign a document that says, if I'm alive but unable to make my financial and legal decisions, then I want this person to be able to do it. Now you could have a power of attorney that says, I want them to be able to get into my safe deposit box, but only on Tuesdays if it's sunny and 70 degrees. And that's what it allows them to do. And then there are these things called general durable powers of attorney that are supposed to say, I let this person do anything and everything that I can do if I were able to do it myself. But those general durable power of attorneys in Missouri don't include like a list of like 12 things that need to be specifically named in the document to be included. And those things would be like making gifts on your behalf, changing beneficiary designations, amending trusts. Now you might say, well, I don't want them to do any of that. I would say, well, we don't know because we don't know what the scenario is. A lot of times we need all of those gifts to protect assets. If you go into long-term care and you're looking at spending $10,000 a month until all your money's gone, we can oftentimes save at least half the money if we have somebody who can act as your fiduciary and do these things. Now, we're not doing it so that they can keep the money instead of you. We're doing it to protect it for your benefit and to follow your estate plan. If we were naming somebody that we thought would steal all your money and run off to Mexico with it, we shouldn't be naming them in the first place. So only name someone that you would trust with all of those things. And some people say, well, I have my kid on my bank account, so there's not really any issues, right? Or I have a trust and both myself and my spouse are on that. So they should have access to that, right? Does anybody have any retirement accounts, IRAs and 401ks? Anybody have anybody else's name on that, or is that in the trust? Or you might have as trust, or you might have them as beneficiaries, or a trust as a beneficiary, but they can't be an owner. The only owner of an IRA and a 401k has to be the plan participant while the plan participant is alive. That's why your spouse is not a joint owner on your IRAs for your adult kids. So an IRA, when it's time to make your required minimum distributions, who can order that for you if you can't do it yourself? No one, unless you have a property power of attorney. I don't know. I'm pretty good at forging my spouse's signature now. You're not allowed to do that. And some things have to have medallion signature guarantees and notaries and all sorts of things that are going to prevent that from happening. Or if they want to sell a house and it's in both names, guess what? The title company is going to want both signatures on the deed. If one of them can't sign it, we're in trouble. But property power of attorney is something that is really important. But the thing I want you to keep in mind is if you have it in place, pull it out, do your best to try to read it or go visit your attorney if they're still around and you have any relationship to review it, make sure it still covers the things that really happen. The things I would look for is, again, we talked last session, somebody else talked about Medicaid and VA planning and stuff like that. Are there gifting provisions in there? Another thing to look at is it immediate upon execution or is it springing? And the difference between that is immediate upon execution means as soon as you sign it, the person you name has the ability to sign your name, even if you can do it. Whereas springing power of attorney requires, by default, 2 doctors to determine you can't make your own decisions before they can do anything. Now, what's the problem with that? Now, on its face, a lot of people are like, that sounds great. I don't want my kid to do anything if I can do it myself. Again, if you trust them to do it when you can't do it yourself, you should trust them to do it when you can keep an eye on it. And the problem with having a springing is either you can do it or they can do it. there needs to be a clear break because I need to go get two doctors to declare you're incapacitated and can't make decisions before they have the ability to do it. And it's rare, again, that everybody can make all decisions, no decisions. What usually happens? You're doing everything, you don't need any help, and then, okay, I could use a little bit of help doing some things, and then eventually, maybe over time, that person's doing more of the things than you are, and then maybe eventually you're not participating, but I'd rather not have to get that. It's not a fun thing to have to go get somebody declared incapacitated. You know, usually they're like, well, they understand most things, and then they know who the family is, they know what their assets are, they just forget to open their mail and pay their bills. You know, it's just not as important as it used to be. Okay, well, we just don't want mom's, water to get shut off. So we want to help a little bit. Or they don't want to spend 2 hours on the phone arguing with Charter about their cable bill. I'll do that part for them, but they'll handle most of their day-to-day stuff. We already talked a lot about the healthcare power of attorney, but that is very, very important.
On the previous one, is that property power of attorney a separate document, or if you have an all-inclusive general fiduciary power of attorney that can be part of that?
Usually there's two separate documents for the financial and legal, and then the healthcare.
Right.
I guess theoretically you could write in powers for all of those things. It would be rare because they're just two vastly different things. So, like, for my mom, I'm the second of 7 kids. I already gave up that I went to the cement slew, so we're Catholic, right? So, and 6 of us are boys, and my eldest brother is really smart and a good kid too. He just lives in Scottsdale, and I live here and I do this stuff. So it makes sense that I would be her first. My dad passed away suddenly at 61, so that's a story for a different day. But basically, I made sense to take over as trustee and executor and power of attorney for my mom on the financial legal side. But the healthcare stuff, like, there's a reason I became a lawyer and not a doctor. I don't like being in the hospital for the birth of my own children, much less, ongoing stuff. And yet my sister, the blessing and the curse of being the only girl in 7, the rose between the thorns, is she's better fit for that kind of stuff. She sits there and takes notes about everything about her knee replacement surgery and what physical therapy is supposed to be happening and what pills is she taking. And now sometimes they kind of meet in this middle, like, what Medicare supplement did mom have to cover these things? Like, okay, that kind of involves me because it's a financial, legal kind of thing. But also the healthcare side, I need my sister who's been going to all the doctor's appointments. So sometimes there's a better person for the healthcare that's not a financial person or vice versa. So it makes sense usually to put those on different documents. And that's the way I'll see them most of the time.
Can you name in advance several different, like, spouse first, the spouse is not available?
Yeah.
Son or whatever.
Yep, exactly. And most times that's exactly what I would do is, you're not trying hard enough if I can get you to the who next until you're just, totally out of options. Because why not take this opportunity? If we're doing it once, then let's think about, all right, let's pretend that person then let's pretend that one. So how many? I don't know, as many as you can comfortably name. 3 is typical, the current, and then maybe first alternate and second alternate. But again, you could name 7 and I would not name 7 at a time before we get to that, or maybe I'll clear that up after this question.
My question is, can you have 2 people named as attorneys?
Yeah, no. The state statute actually says, and there is a resource on Missouri from the Missouri Bar on healthcare documents, where I do kind of trust that as a first free. If you're only going to do healthcare documents, maybe try that one. And they specifically say in the law, like, you may name multiple successor agents, but you cannot name more than one agent at one time. And why do you think that is?
They want.
Yeah. Do you want to? Does a doctor want to go there and have one person say pull the plug and the other person say no, and both of them have equal say? No. They want y'all to talk in a family waiting room or whatever, and then whoever if you think of Family Feud, all of them are, when they're trying to steal, they all say their answer, but only the person at the end is saying the family decision, and that's what they want. Now, financial power of attorney, there's no hard and fast rule against co-agents. I still would prefer not. I would rather have a benevolent dictator in all positions. If you love your kids equally, make them equal beneficiaries. But name the best person for each job for these fiduciary positions, because they are a job. If anything, name the person you hate the most. Because it's a lot of work when things happen to have to go around and do all these things. So again, a lot of people, I know moms and dads, and again, I'm a parent of 3 kids, and I know how you always want to make sure everybody's equal and all that. But remember, these are jobs, so name the best person for the job, if you can.
But on the healthcare power of attorney, when my mom was in the hospital, they were getting ready to put her on a respirator, and they said, "Okay, you have to decide what to do." We all stood there and stared at each other. I don't know. I don't want to put her on a respirator. What do we do? The doctor came in and said, "Don't worry, I've got her healthcare directive. I know what to do," and we didn't have to make a decision.
Yeah. So
is that still relevant? That was 20 years ago. It's still relevant today that it's stated in the papers. The doctor has the papers, and they can.
Yeah. So what you're kind of talking about is the advanced directive living will portions, which I'll talk about in a second. But what I will say about that is 20 years ago, it was a lot more likely for doctors to go like this. What do we want to do? Right? And the problem is there are entire sects of lawyers that sue hospitals for that, because that is not the law. And even if we think everybody agrees, when there's death and money involved, a lot of times things change and we're looking for somebody to blame. Are they going to blame their brother or sister that also doesn't have any money? They're going to try to find the money, right? At least the lawyers are, because lawyers don't sue people without money. You know why? Nothing to collect. It doesn't matter if they're liable or not. They're what we call judgment proof. But if you can find a malpractice insurance carrier or something to hit, they're going to do it. Now, thankfully, I'm not that kind of blood-sucking lawyer, right? But I try to keep you out of that trouble. So what you should do is have these documents in place. But one thing that I'll say about living wills and advanced directives is exactly the point I was making before, is it is your decision about whether you put on that respirator. That's what a living will and advanced directive and all those things say. Now, the problem is when I sign something that says if there's no hope of significant recovery, and 2 doctors have determined that my death will occur whether or not life-sustaining procedures are utilized, and the application of those procedures would serve only to artificially prolong the dying process, and I am unable to participate in those decisions, then I just want to be made comfortable and all death-prolonging procedures be removed. Now, what's the problem with that? What's hope? What's significant recovery? You know, there's a lot of things in there that you really should have an agent that's telling that doctor this is what they meant by that. Because I have all those things initial that I don't want a ventilator when I'm in that position. But that doesn't mean don't give it to me if there's hope. It doesn't mean don't give it to me if it will make me more comfortable. It means don't give it to me if there's no hope, and that will not help. Now, when I say you should name one at a time to make decisions, that doesn't mean only one of your kids gets to find out information from the doctor, right? That's a separate document. That's HIPAA authorization. You could name all 7 of your kids on the HIPAA. So if they find out mom was rushed to the hospital and she's going to Mercy South, and they call Mercy South and say, "Oh my gosh, I hear my mother was brought in. How is she doing?" They can't even confirm that she's there unless you're authorized under HIPAA. So if you have some sort of HIPAA authorization, that'll allow you to find out what's going on. It won't allow you to say, "Hey, don't give her the red pill, give her the blue pill." That's the healthcare power of attorney. But the HIPAA authorization is very important. Now, a lot of us, if you go in for a doctor's visit or a surgery or whatever, they might have you sign a HIPAA form, right? But sometimes you can't sign it on the way in. So I'm cool with you signing their form when you're able to do that for whoever you want them to talk to. But sometimes you need to have this base level of stuff there in case you can't sign on the way in. I mentioned again, advanced directives and living wills, and I'll get in a little bit more detail a little later about all the things that I haven't talked about. So Bill and Mary, getting back to our story, came in, did all their planning, got all those essential documents in, and Bill has a stroke many years later, and he can't communicate. And Mary's trying to find out how he's doing, but she can't get any information. So if Bill's unable to communicate, how are we going to be able to get consent to get any information? So she calls our office and we say, hey, remember in your healthcare documents, one of them is called a HIPAA release. And on that HIPAA release that Bill signed, he gave you the authority to find out any medical information. So just make sure the hospital has a copy of that HIPAA. With that, she can find out how Bill's doing, what room he's in. Now again, a lot of times, will doctors and hospitals say, well, you're the spouse, maybe it's okay. Has anybody had blended family scenarios where maybe if Mary's stepmom and John and Susan kids, and they're battling over who's finding out information? I mean, there's literally stories I have seen where they don't want mom to know what hospital dad's in, or don't want stepmom to know what hospital dad's in. And so again, if you want, make sure that person's on there. But again, that's only limited to receiving health information. It does not authorize Mary to make any medical decision. Unfortunately, Bill and Mary are residents of Missouri, so we have to come up with another document for that. And we remind her, hey, Bill authorized you to make those medical decisions if he's unable to, because he also signed this healthcare power of attorney. And to help guide your decision, there was a living will and advanced directive tied into that as well. Now, if this stroke left Bill totally incapacitated and he's unable to manage his finances, I already kind of alluded to this, but what kind of things come up when that happens? Maybe Bill took care of all the bills and now Mary's like, I need to make sure all our bills keep getting paid. You know, I need to communicate with the utilities. I need to make sure the credit card companies get paid. I need to make sure all this what's going on. Well, even if they have a trust, assets that are in the trust, she would probably be a co-trustee where she could write all those documents and all those things. But we remind her, you know, IRAs aren't going to be in the trust. And this time of year, if you haven't already, you're probably getting a lot of letters from your financial companies saying, hey, your required minimum distributions need to be pulled out by the end of the year, or else what happens? 50% penalty. Now, there are a lot of bad taxes and penalties in this world, but 50% is about as bad as it gets. So if you don't have access to this IRA and we're coming up on the end of the year and your required minimum distribution was supposed to be $10,000 this year for Bill and you didn't take it out, that was a $5,000 mistake and problem. So we aren't going to have time to do it the other way that I'm going to tell you about. We really want to have this stuff in place. Again, marriage is not sufficient. Forgery is not sufficient. We need to make sure that the property power of attorney allows her to manage the finances, kind of allows Mary to step into the shoes of Bill. That's why we got the cool shoe graphic up there. Anything Bill can do, Mary can do. Now, there are a few things that by law she can't allow Bill to sign. Like Mary cannot create a will for him. Mary cannot sign a living will or advance directive for him. Again, those decisions are personal to you, so you need to do that before it's too late. Healthcare power of attorney will help manage the healthcare decisions, all those things we talked about. Again, we can't tailor every single thing that might happen when somebody has a stroke because we didn't know. If you can tell me, you know, what medical events are going to happen to you and how bad it's going to leave you, when and how long you're going to live and when you're going to die, then I'll tell you the right answer. Otherwise, all we can do is give you tools to be flexible when these things happen. Maybe Bill didn't have a stroke, maybe he got cancer and it was a different scenario. Maybe he didn't have a stroke, maybe he had a heart attack. So we really just want to arm with general information and powers. One of the things that does come up though is, since we're here with Voice, who does a lot of work in facility settings as well as home care and everything else. A lot of times when a stroke happens, what's the next step? if they recover enough to leave the hospital. Rehab, right? And maybe it's in a long-term facility, long-term care facility. Maybe it's at home. Don't know. I mentioned we got 100 skilled nursing facilities within 25 miles. How do we choose which one you should go to? Has anybody been in that scenario before for a loved one where you're trying to find out? And what happens? Find an empty bed for one. How did you get it even where to start?
My mother had a stroke and we were thinking she was going home and they said, well, what facility is this? We had like 2 hours.
That's what I was gonna say. How much warning did they give you to find?
A couple hours. And I don't know who would find it, but,
Right.
Hospitals have a person who specializes. That would be the first step anyway, finding they're the ones that do that.
They're supposed to, but yeah, like you said, they're the ones that are coming into you and saying, what facility would you like to go to? You have until 3 o'clock to be out of here. And again, it's not, is that enough time for you to go visit and see what they smell like and see what the care looks like or anything like that? No, it's, oh, I have 2 options and one of them has a bed. Okay, well, good news is I don't really have any options, do I? Now, good news is you're gonna have pretty good luck if you are discharged on rehab. Does anybody know why? Because it's Medicare covered. And Medicare covered rehab, like those are like $300 to $550 a day beds that your insurance covers. But Medicare and your supplement, people hear, oh, it covers up to 100 days, right? Anybody gotten 100 days before in that scenario? It's very, very rare. Up to 100 days, but only while you're rehabbing. And they can say rehab is over on Tuesday. You still need long-term care, but we ain't paying for it anymore. Now that's fine if you can afford $300 to $550 a day for the rest of their lives. But oftentimes that's when we're looking into Medicaid at some point, which it may be harder to find a Medicaid bed available that says, we can take this person under the needs-based program. And again, that's a topic that I teach a 2-hour class at the community college for that we don't have time for today. And one of the some tips that I'll give you too is, just like everything else, don't wait until it's too late, right? We used to have a sign in our office that says, be nice to your kids, they choose your nursing home, but they don't have to, right? If you check it out before it's too late, or maybe you just have experiences visiting other people, communicate. Hey, if I ever get sick, don't ever put me in that place. I realize that if I have to go somewhere, this place is better than that place, so try to aim for that. The other tip I'll give you, the most important thing that I find in people's success and happiness in a rehab or long-term care scenario, any guesses? How often they're visiting. So find location first. It could be closest to your house, but maybe it's the place in between your kids' work and home that they have to drive by every single day, that it's more likely they're going to stop in and check on you at dinner time or whatever else the case may be. And then do like a little radius of a few miles around that place if you aren't having luck. We had one person the other day, we have 3 social workers in our office. Geriatric care manager, licensed clinical social worker, MSW, one of which had a lot of experience doing what you're talking about, the discharge planning. And we had a client that couldn't find a place. The kids were calling all over, couldn't find a place. Now this dad was not in a hospital. He was at home, but he had dementia, developing a lot of behavioral issues that was really wearing on mom. And she's like, I can't do it anymore. Sometimes healthy spouse becomes a dead spouse because of that, or a healthy spouse becomes unhealthier spouse because she's trying to pull up 200-pound dad when she's a 100-pound mom and, pulls her back out. And now she's in skilled nursing and dad's pleasantly unaware wherever he is, right? So unfortunately, he's been in the penalty box before in other care situations. And so when you apply to these facilities, they have his medical records and they can find certain behavioral issues that they don't want to bring into their facility. So we call around 7, 8 different places and couldn't find a place. We finally found a place that would accept that. So especially if there are behavioral issues or other things, it's not something you want to wait until you're in that last second scenario. What other documents exist? Living will. So the living will is that general statement that I basically recited to you earlier. If it sounded too perfect to be made up on the spot, it wasn't. It's the Missouri state language that basically says to the hospital, this person's okay to be removed from life support, because as I said, the default rule is keep you alive. The hospital's job is to stabilize you and make you better if they can. Their job is not to determine when you die. That's your decision. So we need to have a living will in place if there's a point on the line where you wouldn't want to do it anymore. What about a healthcare directive? And how specific should we get? Because the healthcare directive is where you can get a little more specific. One of the things you might have done before you go through your initial feeding tubes or artificial hydration or radiation and chemotherapy. Now, again, if the radiation and chemotherapy will heal the cancer and I will make a full recovery, then by me initialing that does not mean I don't want that. It means I don't want it when there's no hope of significant recovery and my condition is terminal, substantial brain damage, brain disease, or there's no hope of recovery.
So is the healthcare directive part of the living will? Are they two separate documents, or
It comes both ways. So a lot of times you're going to find those combined as one document. The general paragraph of living is the living will. That is in state statutes that the hospitals can rely on, etc. The advanced directives are more tailored. Now, a lot of times you'll see both in the same document. We do them both in the same document, then we have a healthcare power of attorney, then we have a HIPAA, but not always. I would look for them probably together, though, in most cases.
so when you said 5 documents, you're looking at them as separate, or were they combined? I'm trying to.
I don't know. Power of attorney, healthcare power of attorney. No, I got to remember HIPAA authorization, advanced directives. I think I have them all laid out here. Maybe I have living will is the. All right, then I say many people should have a will or a trust, but that's not one of the must-have documents. So yeah, they're two separate things, but a lot of times they'll be together, right? What confuses me, I've been doing this for 15 years. I've been looking at it a while. So how specific should I get? I've gotten to this a couple of times, but one thing that I put, again, being Catholic, we have some weird things about end of life, right? Last rites or anointing of the sick is something. So like I have in my advanced directive, being Catholic, before you pull me off the machine, try to get a priest in there to give me anointing the sick. I didn't waste my whole life going to Catholic grade schools and high schools and college to throw it away on the half-yard line. That's what makes the difference, right? Now that's come up too. I've had a client that, of course, when does it happen? Christmas Eve. He's on life support. He's not going to get better. Doctors are recommending removing it. And I mentioned, because this is before I learned that it was so important to put religious things in there. This was a lifelong bachelor in his 90s, and I had known him for a bunch of years. Had a lot of conversations with him, and he was one of those go to church every morning at 7 a.m. guys. And when it was this time to come, I said, hey, I know it would be important to him to receive last rites. Is that something that you can get for him? Well, and it's Christmas Eve at 6 o'clock at night. They're like, not really. We have a Baptist minister that can pray on him that's walking around here. And he said, I don't think that's what he would want. Is he in a lot of pain? When can we get one there? You know, they said, well, we call around, we can get somebody there at 7 a.m. tomorrow. And he's not going to be in any kind of pain, you know, that sort of thing. But I wish that it didn't wait until that point, and then we could have prepared for that, because I mean, my mom's gotten the anointing the sick like 3 times, right? Like, you rather shoot for getting it and not needing it than the other way. Now, most like Lutheran, Methodist, Baptist, there aren't anything specific like that. If you're Jehovah's Witness and you can't have blood transfusions, and Orthodox Jewish, and there's a lot of things involved there, but that's stuff in there. It should play a part. So again, healthcare documents, HIPAA release authorizes the release. What if you don't have those documents in place? Let's look at Rachel and Mike. And I know that I'll make sure we end on time. I taught Finance 1000 at Mizzou for a couple of years and 60 college kids, and I can tell you the worst thing on earth you could do is be over your time. I'll never do that. So this was on their, this is on their list of things to do, right? Exercise program starts on Monday. One day I'll plan a vacation. I want to volunteer more. Oh, I need to do my planning. Unfortunately, I never got to it. It stayed on the list of things to do. And Rachel passed away suddenly, and without Rachel by his side, Mike had dropped kind of quickly into dementia, couldn't manage his own finances, couldn't choose an appropriate care plan with his doctor. So their son, Jason, has no legal authority to do any of this stuff on his behalf. And because his dad lacks capacity now, it's too late to have him sign it. And we've had people say, oh, dad will sign anything. It's put in front of his face. Like, well, that's not the way legal documents work. Right? And again, these things have to be witnessed and notarized. And there's a reason the property powers of attorney are not that widely available. Why do you think you can't just Google property power of attorney and print one off? Anybody think it's dangerous to let somebody just get access to everyone's finances by having them sign something they don't understand, and now they have access to all their bank accounts and brokerage accounts? And so to protect these people, we have this process called guardianship and conservatorship. Now, a lot of times we think of it as for minor children, right? If you pass away and you have a 5-year-old, somebody needs to raise them, you have guardianship. Well, sometimes adults need guardianship. And sometimes it's temporary. If you see Britney Spears, you know, or Michael Orr. Sometimes it's end of life abuse stuff like Casey Kasem, Mickey Rooney. There are all sorts of examples of people where the court is there to protect people from being taken advantage of. But in this case, it's because we have no authority without that. So guardianship and conservatorship is actually Jason suing Mike to take away his ability to make his own decisions. And the court removes that decision-making from Mike and gives it to Jason, if they agree. Now, a lot of times people will tell you, oh, just go get a guardianship. And they'll tell you that like you're picking up a dozen eggs at the grocery store. That ain't the way it works. As you can imagine, the court isn't that quick to just take away an adult's rights to make their own decision. We have to have doctors' interrogatories, which means the doctor's testimony that this person lacks the ability to make and communicate their own decisions and they're a danger to themselves or others. But even with that, we still have to have a hearing, because having a diagnosis of dementia doesn't mean you lack the capacity to make your own decisions. There's a lot of room in there. If you have powers of attorney, for instance, you might be able to prevent it 99 times out of 100. And the second thing is, even if it's appropriate to have a guardian, how do we know Jason's the right person? You know, a lot of times we have, well, Jason's lived with dad for 20 years. Why do you do that? He's taking care of him? It's because he doesn't like having a job. I mean, he likes spending the social security check. Or maybe Jason's the one that lives out of town and a different kid is a better person to do it. You don't know. But this puts the court in control. Why do we care? Why do we know about Britney Spears and Michael Orr and all these other cases? Because it's public. In Missouri, you can look up on CaseNet almost anything. It used to be a little bit harder to get into, but now you could get in one of these computers right here and go to CaseNet and probably pull up anything that's been in the probate court. Very few of them are sealed to the public. Some of them used to be sealed kind of normal people, but lawyers could get more information. Now a lot of that stuff's even out. That can be embarrassing, certainly costly. I didn't put on my tie today because I like to say anytime I have to put a tie on, it usually gets expensive. So annual accountings, going to court, all that stuff, and it takes months to get through too. So here we go. See, I got them on 2 separate dots there. Power of attorney, healthcare power of attorney, living will, advance directive, tip authorization. Those are kind of the main things that I would say. Everybody, how many times did we talk about because you're saving millions of dollars? 0, right? How many people, how much money do you have to have for those things to be important? And nothing to do with how much money's there, how much money you're saving, your taxes. Now, many people should also have a will or a trust. of which I have both. Again, it's its own talk, but just to kind of lay that out and then leave a few minutes to answer any other questions that we didn't have along the way. Most people think about estate planning like I have to sign my will, right? I got to get my will done. But what's a lot of people's main priority when they do estate planning? They say, I want to avoid taxes, and I heard another one, probate, right? And what's the problem with a will? Yeah, a will doesn't avoid probate. A will directs probate. What does that mean? It means a will doesn't mean anything anywhere in the world except probate court. Now, that's the way that it's been done for hundreds of years. Someone dies, we have a house that was owned by Bill and Mary. Bill and Mary died. Who gets it next? They had a will. They said they wanted to go equally to John and Susan, and Susan's the executor. What's the problem with that? Well, nothing if you don't mind it taking 9 months to 2 years. If you don't mind it costing 7 to 10% of the value of the estate. If you don't mind it being public to anybody Googling it from the local public library. A lot of people want to avoid probate. You can't just go to Bank of America and say, see, I'm Susan, I'm the executor on my mom and dad's will, and myself and my brother are the beneficiaries. If you would kindly give me access to that account, they would say, go get letters testamentary. Again, they tell you that like it's something very easy to do. It's not. It's the full probate process. Now, I still have a will because a will is the only place that you can designate a legal guardian. You can't privately deal children, so that's okay. So we have who would raise, who would be the guardian. Nothing more important in any estate plan if you have minor children, but that's not where we want the money to go. That's the expensive part. And the other problem with using that is how many people think a 5-year-old should get a lump sum of money? All right, you know how many monster trucks would be in his house? But if you have, that wouldn't really happen. If I have life insurance and I said I want my wife to get it, and if she dies, then my 3 kids, and my wife and I die in a car accident, it doesn't go to a 5-year-old, a 7-year-old, a 9-year-old. It goes to probate and it's held in a conservatorship, where the legal guardian will have to ask if they can buy monster trucks or enroll them in soccer that can get approval for everything that happens with that money until they're 18. How many people think 18 years old is the right age to get a lump sum of money? I've never met an 18-year-old that I say, here's $1 million, go do something smart with it. They've never earned any money. They don't. And the bad, dirty secret is inherited money feels different than the money you've earned and worked for your whole life. This is true of even smart, responsible adults. It feels like woohoo, happy birthday money. Whether it's $20,000, $200,000, $2 million, the average person spends their inheritance in 18 months from the time they get it. It's totally gone. Some much faster than that, because that factors in the people that don't blow it. But if you don't want to leave somebody with a really happy 1.5 years, then you might want to think of something different than just give it all to them. So a trust is one way to do that. But a trust is not a trust without a trust. We sometimes do trusts that are asset protection trusts, like we're afraid of getting sued, or if we're afraid of long-term care costs, you might need specific provisions. It might need to be irrevocable. Again, those things are too detailed to go into in 90 seconds. So this is just kind of something that I wanted to lay out. And the other thing is, if you do have a trust-based plan, you gotta check into the funding. Like, are things actually titled to the trust? Is the beneficiary actually the trust? Because a lot of you think, not you personally, but a lot of people in the public think as soon as you sign the document, everything you have is owned by it. No, you got to go to Charles Schwab and move that money. You got to go to Commerce Bank and move that. You got to go to New York Life and change your life insurance benefit. You got to do all that. You got to go to the DMV and add TOD on your cars to your trust. You got to record with the county recorder of deeds. And again, there are other ways to avoid probate, but funding and the tax efficiency and everything else, you're generally going to have either a trust or will-based plan. So a man who procrastinates and is choosing whenever we have his choice made for him by circumstance. So for the best chance of a quality end of life, you have to plan for your end of life. And as promised, we answered questions along the way. So don't feel that bad that I left 48 seconds or whatever for questions, but I'll stick around if anybody has any other questions. I know Voice is such a great resource for all this stuff too. It is truly a great resource for us to have in and around the St. Louis area. We, as a law firm, sponsor a lot of what they do, not only these education things, but with donations of money. To have these resources is just such a great thing. So if you're ever in a scenario where you need some help, that's a good place to start.